estates. It's really a customized plan. And one important thing about estate planning is the time to do it is when you don't really think it's needed, because this is a time when you have harmony in your family. The worst thing you do is you wait until there's an emergency, and we've seen that happen in our office. Usually clients come in and the husband finds out he has some medical need and he has to go in for an operation. He's going to go in the next day. Of course, they come to our office very frantic, very nervous, and they want to do things right away. Well, that's not a good time to be making these type of decisions when you're under a lot of pressure. And it's very nice to go into a law office and sit down with your attorney and your CPA and make these type of decisions when you have a rational frame of mind. And you can sit down and talk about it, husband and wife, because these are not the topics you talk about at everyday dinner table. You know, what do you want to be doing in case you have mental incapacity, in case you have a stroke? What type of decisions would you want made? It's good to do that in a formal setting. It really forces people to sit down and think about the consequences of what happens within their family. And when the tragic thing happens and people are very, very nervous and they're trying to make decisions, the wrong things occur. So this is why we have to do pre-planning, do it early on. And these days, you know, people travel together, husband and wife fly in airplanes together. You saw what happened here on the news lately. We had John Kennedy Jr. These things are not expected, right? People go, they're flying to a meeting and airplane crashes, unexpected. Now, I don't even know if he did any estate planning, but it'd be interesting to see, because I know his mother, she did a will, because speaking back about the living trust versus will, the will is a public record document. The probate estate and the will gets published to the court. So anybody can go in and look at that document. We have a copy of Jackie Onassis's will. We got it from the public record. Very interesting to read. A living trust, a private, confidential document. So that's another reason to keep things private in the family, is we do this estate planning in the privacy of a law office. It's in a formal setting. We discuss everything with the various family members and make the proper decisions. And it's amazing how personal things come up, things people haven't talked about for many, many years. It becomes almost an emotional issue sometimes doing your estate planning. We've had husband and wife in our office, and out comes a situation where the husband has a daughter from 20, 30 years ago. He didn't even want to mention. Nobody talked about it for 20 years. Now it's an issue. Is she going to inherit from the estate? Well, let's deal with it now. This is a much better time to deal with these very complex matters and emotional matters in a professional setting rather than have your heirs worry about it. And just think of the nightmare of a death of this person, and competing parts of the estate and competing beneficiaries are going to be challenging these decisions without a formal document. That document really states the wishes of the person. That's why we should also talk about medical conditions. In these tragic situations where people have medical problems, not only do we need to make financial decisions, but we have to make medical decisions too. There are decisions to be made now on life support, on feeding. When you're in a comatose state, you cannot communicate to your doctor your needs. You cannot communicate what your wishes are. There could be religious beliefs, there could be personal beliefs. It's very political these days. You've got the right to life movement versus the right to die movement, and everybody's competing for these political posturing, and you become more or less the guinea pig, right? They're going to go to court and make decisions for you. Well, all they're looking for, this is all the court is looking for, is that one document. And all the doctors want is that one document. That's a directive to a physician and a durable power of attorney for health care. They call it like a living will. And that is a document that designates what medical treatment you want. And when I meet with clients, I do not tell them what they should do. I ask them, what are your wishes? And then they designate what they want. Then we fill out the forms on their behalf. Everybody has a different scenario. Some people want to be kept alive by extraordinary means as long as possible. Okay, that's your decision. Other people, if there is a comatose state, they would rather have support and treatment decline. That's their choice too. Some people pick a more middle-of-the-road approach. That's where you look at the quality of your life versus the suffering and make an intelligent decision on what they should proceed with. That's a fine choice too. So whatever people want to do, we let them make that choice. But at least make it in a professional setting. Don't make it in a setting where you're under pressure. And this creates a situation where husband, wife, children really can think about these really serious matters. And the doctors don't know. And the courts don't know. And what they want to do when people are in that state, and there's been some very famous cases, I know about 10, 15 years ago, Karen Ann Quinlan went to court, their family went to court, there was a big scandal about political maneuvering by everybody. But really what they want to do is they want to know, what does the person want? And the person obviously can't speak at that moment because they're mentally and physically incapable of speaking to the doctor. or speaking to their family. So they really want to know, what does that person want? Well, wouldn't it be nice to pull out that document, have it pre-signed, notarized, everything designated? And it becomes a private affair between the family and the doctors. So part of that comprehensive estate plan, we have the living trust, we have the durable power of attorney for asset management, now we have this living will, durable power of attorney for health care, the one that survives incapacity. So it continues on. And it also designates donation of organs, which is an important thing these days, disposition of remains, if people want cremation or burial. It also talks about perhaps special situations if people don't want blood transfusions or if they want maybe special type of treatments. All of that can be designated in that document. So really, when we talk about estate planning, this is a comprehensive estate plan. It's not just a living trust. People call our office and say, I want a living trust. I go, you really want a comprehensive estate plan. So we're going to take care of everything at one time. We're going to have the living trust done, we're going to have the durable power of attorney for managing assets, and the durable power of attorney for health care. And then the will. We still do a will. Even though we're doing the trust, we do a will, but it's a peripheral document. We call it a pour-over will. What it does is it takes the assets through the will and it pours it over into the living trust. Because not everything do you title in the trust. It's very hard to put title to things like furniture. Maybe you have a grand piano. There's no real title certificate to it. We can do a letter, for example, designating all the various assets that they're in the trust. But there's always things that you omit. There might be small bank accounts, there might be vehicles that aren't very significant in value. Those are picked up by the will and poured over into the trust. So the trust becomes more or less like a funnel. Everything goes in through that and gets distributed to the proper beneficiaries. So that's a pretty broad perspective on estate planning, living trusts. We can also do other types of trusts. Life insurance. Now, life insurance proceeds, they can go into the trust, but we have to be careful because we should talk a little bit about estate tax. Historically, until most recently, the exclusion was $600,000. That means each person gets $600,000 exemption. That's a unified credit lifetime exemption. Throughout your life, you get $600,000. Now it's indexed for inflation. It's going to go up to $625,000, and then from there, it's going to eventually go up to $1 million. $650,000 now. It just went up to $650,000. So eventually it's going to go up to $1 million. People think that's a lot of money. It's really not these days. If you live in a home, you have a second home, you have maybe a business, some rental property, amazingly $1 million gets very easily achieved, that level of wealth. So what we do there is we have to be careful with life insurance proceeds because that becomes part of the estate. Anything that you own or control is part of your estate. So if you own a life insurance policy, even though you designated the beneficiaries to be your children, it's still includable in your estate for estate tax purposes. People don't realize that. What we need to do is get that out of your estate. So what we do is we put that into a special life insurance trust. That's a trust just to hold the life insurance policy and the proceeds. Now, when we pay the premiums, what we do is we pay those as gifts. So if the premium's $2,000 a year, we make a gift to the trust of the premiums. We're allowed an exemption per year per person of $10,000. So if you're husband and wife, $20,000. If you have 3 children, 20, 20, and 20, $60,000 a year. So you can really designate quite a bit of gifting to this life insurance trust. And it really depends on your age too. If you're young, you're going to have a small premium. If you're up in the years, you're going to have a very large premium. So we designate those premiums as gifts into the trust. The life insurance trust pays and owns the insurance policy. Now, the control is with an independent trustee. We appoint perhaps an uncle, aunt, brother, sister, somebody to be the trustee of that life insurance trust. So what have we done? We've removed control of the life insurance policy itself. The ownership is removed, and the proceeds are going to the beneficiaries. It's not your policy anymore. You're just the person designated whose life is the one calculating the time that they pay off the death benefit. So it's not part of your estate anymore. And if that life insurance is $1 million and you have $1 million of other assets, that equals $2 million, your estate tax will be about $300,000. So just by moving that into a life insurance trust, you've lowered your estate tax burden by $300,000 at virtually no cost. So I really consider the estate tax to be a penalty for poor planning. Congress has given so many opportunities for people to plan their estate, so their estate tax is zero. So anybody that incurs an estate tax, and many people do, we file in our office many Form 706. That's the form that pays the federal estate tax. And people do write checks for $300,000, $500,000, $1 million, and more. and it comes right out of the beneficiary's proceeds. And the same discussion occurs every time. We tell the family, had you done proper planning, very simple approach, you could